Just like the street lights lit this town, like a fire in a blaze, gotta burn it down. Can't be afraid to leave this out. We got this far, don't know how. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we gonna let it out. Tonight, we gonna let it out. Tonight, we gonna let it out. Just like the sunrise, we gonna let it out. Just like a spark that's breaking out. Can't make a stop, can't turn back now. We know that there's no room for doubt. No, we can't turn back now. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we gonna let it out. Tonight, we gonna let it out. Tonight, we gonna let it out. Just like the sunrise, we gonna let it out.
Good evening, everybody. Welcome in, welcome in, welcome in. I feel like there's something back there, but there is. Everything's on. How's everybody doing tonight? Hopefully you guys are having a great Thursday. Is it Thursday? It is Thursday, right? I'm like, it is Thursday, isn't it? It is, it is, it is. Thank you. Thanks, Olga. Appreciate that. Get you pumped up and get you ready for the live. I kind of hope it does anyway. So if you are new here and this is your first time on the channel, my name is Tanya or TitaniumBuilt. You can call me either or. Don't prefer one over the other one, but whichever is easier for you guys. So we'll go ahead and we'll get started. We're just taking a break from our interviews that we're doing. We have been going back, if this is your first time on the channel, we've been going back in the Idaho 4 case and reviewing just a lot of the information that, came out in the first year, maybe 2 years that we just want to go back and, sorry, dog. We just want to go back and just kind of go through the interviews and all that stuff. So we started with, she's letting herself know there she is. She's like, I'm here tonight, guys, with her little white face. Sorry. But we started with Ethan Chapin, and then we've just been going on from there. So we did Ethan. It took us 2 nights to cover the interviews that his parents have come out and done. And then we did Xana Kernodle, then we did Maddie Mogan, and now we're on Kaylee. Since Kaylee's family has done the most press, I saved her to last. So it'll probably be like 2 or 3 more parts before we get all the interviews done. But new documents came out, so I thought we would take a stop there, go over to the documents and see what they said tonight. So, hey, Ladybug. Hey, Mary Beth. Maybe she does. Do you want to go out there with your sister? Hey, Princess, welcome in. Hey, Cyber Warrior. Hey, Just Breathe. It's good to see everybody. Thank you, Mary Beth, for gifting out memberships. I saw you gifted out a couple memberships. Whoever got them, welcome on in. And we all know to be an adult here and tell Mary Beth thank you, I'm pretty sure. Look at that. PMH got it. See, you guys tell me when I got them because I can't ever see unless some of my other, unless it's on the iPad. So welcome on in. Oh, Mary Beth, you've done more than enough. That's fine. Thank you so much. Oh, no, you should have kept your coffee for tomorrow. You need your coffee. Need your coffee. Gotta have coffee in the morning. That's so funny. Oh, thanks, Ladybug. Yeah, hit the like button for your girl. That would really help me out a lot. Hey, Petunia. Hey, Courtney. Hey, Michael. It really does help the channel. It really, really does. Hey, PM. Crafty One. Pete. Hey, baby girl. Art Sea Gal. I must have came on right at the perfect time. Hey, Olga. Hey, Zaza. Look at that. Cleaned your car, found $20. I love that. I love that. I thought about when you like get to your winter coats, like the next so after this, we just finished this winter, we just put our coats in the closet like half the time. And you'll come the next year and you'll find like money in your pockets. I thought about putting like $5 in each one of my pockets, or like a 5 and then a couple ones, or like maybe a 20, and then surprising myself next, holiday season. I was thinking that the other day. I was like, I could just set myself up for a good thing, Hey, Shells. Hey, Country Thing. Hey, Triple L. I don't know if I said hey to Dawn. Hello, Dawn. And I'm gonna let Miss O'Reilly. Never mind. She's cool with me. Thanks, Ira Warrior. She is the prettiest girl. Hey, Tony. Hey, Stacy. She's a little mixed. Hey, Christy, welcome in. I think I got everybody. If I missed you, I'm sorry. Welcome on in. Welcome, welcome, welcome. Hey, Villanova Law. I always say that 3 times. There's another person on the platform that says welcome, welcome, welcome that Vincent watches. Now I feel like I say it a lot. But I've been saying it for years now, so we're just gonna keep going with it. But there are some new documents, and as I was reading through them today, there were some things that were new. And I was like, oh, I don't remember that from before. So we're gonna go over those documents, and then I'm gonna ask you guys if you guys have seen if this is new stuff to you as well, because I'm pretty sure it is. Let me grab the first one. I hate that they're not like marked very well. For me, I didn't mark them very well. And I'm gonna put myself maybe there. Actually, we could blow it up a little bit too. I forgot we could blow these ones up. Okay. I think everybody can read that. Hey, Classic One. I saw a couple other people come in. Hey, Jessie Scroll. Welcome in, everyone. It's good to see you guys. We'll go ahead and we'll get started. Let me get my glasses on just in case. So the first one that we're going to talk about is going to be the text messages in the 911 call. Remember back from the April 9th hearing, he said that the judge said that parts of the 911 call and the text messages and the phone calls between Dylan and Bethany, some of them they were going to redact, and then some of them they were going to go ahead and keep. They went ahead and they did that in this document here. So when they did that, though, they brought out some new information. So we're going to go through it, and we'll see what's new and what's not. But I do want to do a comparison one of these lives and see exactly what they took out. So I'm going to print out both of them and see exactly what they took out, and we'll go over that in one of our next lives. But introduction says DM and BF are the 2 surviving roommates of 1122 King Road. At the time the homicides were believed to have occurred, DM saw a masked intruder in the house and began calling and texting the other roommates, including BF. Approximately 8 hours after DM saw the intruder, BF called 911 from her phone. Before the court is the state's motion to allow the text messages by DM and BF. Testimony about their conversations with each other about what DM saw in the 911 call. The state argues these communications are either not hearsay or qualify under one or more exception to the hearsay rule. It also asks that a transcript of the 911 call be provided to the jury to view while listening to the audio. Defendant challenges several of the communications and objects to the use of the transcript. Of course. I mean, if it's a transcript, it's going to be what they said. So I guess they don't want them to be able to read what they've said. Oral argument on the motions was held on on April 9th, 2025, after which the court took the matters under advisement. The court finds that some of the hearsay statements on the 911 call do not qualify under the exception cited by the state and therefore must be redacted. However, the balance of the 911 call, as well as the text and conversations noted herein, are likely admissible, provided that the requisite foundation is laid at trial. The transcript will be allowed as a demonstrative aid, again, assuming proper foundation is established. So then we're going to go through the standard. I'm not going to read through I never read through that, like the examples, because I feel like when we say state versus this, state versus that, like it starts to get a little confusing. So that's why I have read X marks through some of them. But I had to stop doing that because my documents weren't loading right. So, but we'll go ahead and we'll get into the standard of it. So whether a statement falls within the present tense, impression, and or excited utterance exception is a question that is left to the sound discretion of the trial court, given consideration of the totality of the circumstances. Use of demonstrative aids is also a discretionary determination. On discretionary matters, the trial court must, 1, correctly perceive the issue as one of the discretion, 2, act within the outer boundaries of its discretion, 3, act consistently with the legal standard applicable to the specific choices available to it, and 4, reach its decision by the exercise of reason. And then this is the facts of the case. Well, thank you, Mary Beth. Look at you. Give the note another membership. You got it. Healing out loud. Hey, Aries. I was going to say, hey, TitaniumBuilt. I read the. Hey, Reba. Hey, everybody. Welcome in, guys. So facts. After spending the evening out, roommates DM, BF, Kayla Gonzalez, and Madison Mogan, they spelled her name Morgan. I just noticed that. Returned to their home at 1122 King Road in the early morning hours of November 13th, 2022. At approximately 2 a.m., they met up in Kaylee's room and talked for a while before going to bed. Now, we never heard that before this. Now, unless you guys have heard that, I have never heard that. They met up with, the fifth roommate, Xana Kernodle, who was out with her boyfriend, Ethan Chapin, was not home yet. The roommates debated going out to a food truck for a late snack, prompting DM to send a text at 2:10 a.m. to an Uber driver she knew to see if he was driving. And it says Exhibit D1. I believe that's what that stands for. Ultimately, however, the girls decided to just go to bed. I wonder At approximately 4 a.m., DM heard strange noises and crying coming from the bathroom. First time we ever heard that. We never heard the DM heard crying from the bathroom. I'm assuming the second floor bathroom. So it would have been closer to Xana's bedroom. But I don't ever remember hearing that before. So it says that she heard crying and noises, strange noises coming from the bathroom. She opened her door at one point and saw a man dressed in black with a ski mask on walking by her bedroom door. She then placed calls and texts to her other roommates to see if they were awake. Only BF, who resided on the ground floor, answered. They spoke once for 24 seconds, during which DM told BF she thought she heard something. They spoke again a minute later for 41 seconds when DM told BF she saw a man in a ski mask leaving the house. They then exchanged the following text messages between 4:22 and 4:26. And I don't know if any of these are redacted, but we'll read through them. It's been a while since we've read through them. So it says DM to BF, no one is answering. DM to BF, I'm really confused right now. DM to Kaylee. DM to BF, what's going on? BF to DM, yeah, dude, WTF. BF to DM, Xana was wearing all black. DM to BF, I'm freaking out right now. DM to BF, no, it's like a ski mask almost. BF to DM, STFU. BF to DM, actually. DM to BF, like he had something over his head and little and mouth. DM to Bethany, Bethany, I'm not kidding. I'm so freaked out. Bethany to Dylan says, so am I. Dylan to Bethany, my phone is going to die. Fuck. Bethany to Dylan, come to my room, run down here. And then Dylan said, I'm screwed though. And then Bethany said, yeah, I know, but it's better than being alone. So this is exhibit D1 and has like a 4. So during the foregoing exchange, DM also attempted contacting Ethan Chapin through Snapchat. She tried calling Kaylee and Xana. She again tried calling Kaylee and Xana, but neither responded. And these are just showing the exhibits, so I'm reading through those. DM then exited her room and began running towards BF's bedroom. On her way, she noticed Xana lying on the floor of her bedroom with her head towards the wall and her feet towards the door. So she would have been like, you would have seen her feet in the doorway, not her head. I'm going to read that again because we didn't know this neither. We never heard this before. So DM says she attempted to contact Ethan Chapin through Snapchat. She again tried calling Kaylee and Xana, but neither responded. DM then exited her room and began running towards Bethany's bedroom. So, you know, I could bring up a map, but when you come out of Dylan's door, she would have went to the right, and then she would have been going around that hall, you know, the living room to go down the stairs, to go down to the first floor. So she would have been able to see right in the doorway there. It says, on her way, she noticed Xana lying on the floor of her bedroom with her head towards the wall and her feet towards the door. DM thought Xana was drunk. Once DM arrived at BF's room, they locked the door and both made additional unanswered calls to the other roommates. At 4:32 a.m., DM again texts Kaylee, please answer. With no response between approximately 5 a.m. and 6:30 a.m., DM engaged in activity on her phone, primarily creating, editing, and deleting images and videos. Her phone activity then ceased until 8:05, when DM accessed Instagram for a few minutes. At 10 a.m., DM again accessed Instagram and communicated over Snapchat. At 10:23, she texted Madison asking, are you up? She received no response. DM continued to access Instagram and Snapchat until 11:29 a.m. when she texted Kaylee, are you up? Again, there was no response, which DM thought was strange because Kaylee and Maddie were early wakers. DM continued accessing various social media sites, including checking Ethan and Xana's Snap Map locations. At approximately 11:40, DM's father texted her about scheduling a time for a chat, to which DM responded. She also okay. Oh, so it wasn't like, that's good to, I mean, I guess it's good. No, I don't know. So it doesn't look like DM called her father, you know, like we thought they were calling, like asking for advice. Like that's what I thought anyway. But it looks like her father had texted her about a time for them to, like, you know, like, I guess, chit chat. It says she also received 2 texts from a person named Jenna stating, bro, and do you guys need me to come get you? At approximately 11:50 a.m., DM called her friend EA and asked her to come over and check the house because she was scared. EA and her boyfriend HJ came over. They met DM and BF at the bottom floor of the house. DM, BF, and HJ started to walk up the stairs to the second floor. When they reached the second floor, HJ went to the kitchen to grab a kitchen knife. So that tells me right there, they knew something really bad happened. Right? Like if he's going, I don't know why you didn't bring a knife with him. Why didn't you bring one with you? But he went into the kitchen and grabbed one. So I don't know. It says, when he came back out, DM saw Xana again for a split second, and I just started bawling because I thought she had just like, I don't even know. I thought maybe she was still drunk and all asleep on the floor. BF also saw Xana lying on the floor. HJ told DM and BF to get out. EA, who had started up the stairs, also turned around after HJ instructed her not to come any further. They both went outside. Shortly afterwards, HJ exited the house and told them to call 911. He was pale white and mentioned something about someone being unconscious. At 11:56 a.m., BF called 911 from her cell phone and spoke to Carolina Calvin, the 911 dispatcher. The call lasted 4 minutes and 11 seconds. During the call, the phone was passed around to different individuals, including BF and DM. And HJ, sorry. And an unidentified female speaker. Heavy breathing and crying can be heard throughout the call. BF spoke first, stating something is happening. Something happened in our house and we don't know what. That states exhibits 2, the 911 call. BF attempted to provide the address of the house to dispatch, but could not continue. At that point, an unidentified female speaker took the phone and provided the address and BF's phone number. The following exchange ensued. So I'm just going to kind of like read through these. Okay. So it says, okay, and tell me exactly what's going on. One of our roommates who passed out and she was drunk last night and she's not waking up. Okay. Oh, and they saw someone in their house. They saw a man in their house last night. Yeah. And are you with the patient? Hi, this is DM. Okay, I need someone to keep the phone. Stop passing it around. Can I just tell you what happened pretty much? What is going on currently is someone passed out right now. I really don't know, but pretty much at 4 a.m. Okay, I need to know what's going on right now. If someone is passed out, can you find that out? Yeah, I'll come. Come on, B. We got to go check, but we have to. Is she passed out? She's passed out. What's wrong? She's not waking up. And then HJ says Xana. DM then informed dispatch that Xana was 20 years old. At that point, HJ took the phone. The dispatch asked him if she was breathing, to which HJ answered no. Law enforcement arrived at that point. After confirming with DM that the responding officer had a defibrillator, dispatch ended the call. Later, at approximately 1:04 p.m. that day, DM received a vandal alert regarding the homicide. And that's when they told everybody just to stay in their homes and stuff. So, analysis, the state seeks to admit DM and BF's phone records from November 13th, 2022, including all phone records and text messages, as well as illicit testimony by DM and BF regarding their communications with each other on November 13th, 2022, that they testified to before the grand jury. The state also seeks to admit the 911 call and the official transcript thereof. The state argues these records and communications are not hearsay, or they are accepted from hearsay as excited utterances or present sense impressions. Defendant objects, arguing that apart from HJ's statement to 911 that Xana was not breathing, the exceptions do not apply to the hearsay statements. The court finds the bulk of the statements are likely admissible, with 3 exceptions of statements made during the 911 call. So hearsay is out of the court statement admitted to prove the truth of the matter asserted. To be hearsay, the statement must be intended as an assertion of fact and offered by the proponent of for purposes of proving the truth of the assertion. If a statement is hearsay to be admitted, it must fall under an exception. Hearsay statements on a 911 call can typically be admitted into evidence under either the public record or business record, exceptions to the hearsay rule. However, because citizens who call 911 are not under any duty to report, a recorded statement by a citizen must satisfy a separate hearsay exception. Typically, these exceptions include the present sense impression exception and the excited utterance exception. The present sense impression exception authorizes the admission of hearsay if it is a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. The rationale justifying the exception is that the immediacy of the statement offers no opportunity for fabrication. The rule recognizes that in many, if not most, instances, precise contemporaneity, I only can't even say that word, is not possible, and hence a slight lapse is allowable. It says, quoting, okay, advisory committee role, or note, sorry. Okay. The excited utterance exception to the hearsay rule authorizes the omission of hearsay if the testimony recounts a statement relating to a startling event or condition while the declarant was under the stress of excitement caused by the event or condition. To fall within the excited utterance exception, 1, there must be a startling event that renders inoperative the normal reflective thought process of the observer, and 2, the declarant's statement must be spontaneous reaction to that event rather than the result of reflective thought. So, no forethought, just something that just comes right out of your mouth. In considering whether a statement meets the excited utterance requirements, the totality of circumstances must be considered, including the amount of time that elapsed between the startling event and the statement, the nature of the condition or event, and the age of and condition of the declarant, the presence or absence of self-interest, and whether the statement was volunteered or made in response to a question. There is no bright line rule as to the allowable time span between the event and the statement, and one likely should not be drawn. As with the present sense impression exception, the rationale underlying the excited utterance exception is the special relatability, which is regarded as furnished by the excitement suspending the declarant's powers of reflection and fabrication. Okay. So, number A, or letter A, letter A. Text messages and verbal conversations between DM and BF are likely admissible. So these are his rulings. As an initial matter, the court finds that DM and BF's acts of making phone calls, sending or receiving text messages, and other phone activities such as accessing social media are not hearsay. Hearsay only captures an oral assertion, written assertion, or nonverbal conduct intended as an assertion. Thus, this order will focus on the content of those calls and texts to the extent available. As to the content of DM and BF's text messages about what DM saw, the court finds they are either not hearsay because they are not offered for the truth of the matter asserted or not assertions, or if hearsay, they are likely qualify as a present sense impression and or excited utterance as set forth in Exhibit A hereto. Their verbal discussions are potentially admissible for these same reasons. The state must establish the foundational requirements for such proffered statements at the time of trial. So, number 1, DM text Uber driver at 2:10 to inquire if he is driving. So that's why, how we were wondering why DM had, why she was texting an Uber driver at that time to see if he was driving. It was to go get food. That's why, they were wanting to get the car. So then it says text messages between 4:22 and 4:26. And I'm pretty sure there's some more stuff in here too that's new. The state argues that the 4-minute series of text messages between DM and BF with one from DM to Kaylee are admissible as either present sense impressions or excited utterances. Defendants suggest neither exception applies because there is no evidence that they were sufficiently startled by the events. He points out that DM claimed only to be confused, and despite stating she was scared, she ran to BF's room instead of leaving the house or otherwise calling other friends and family for help. The court agrees with the state for those texts qualifying as assertions. First, the present sense impression exception does not require a startling event. It simply requires the speaker described or explain a condition while personally perceiving it or immediately thereafter. Most of DM's texts to BF satisfy this exception. She first texts that no one is answering, which describes the results of her calls to the other roommates just moments before. She also states what she is immediately feeling: confused, freaked out, and scared over what she just saw and heard and the fact that none of her roommates are answering. She further describes the intruder she saw, i.e., wearing a ski mask or something over his forehead and mouth. She also relays that her phone is going to die, thus these statements are all likely admissible as present sense impressions. In addition, the events are sufficiently startling to both DM and BF for purposes of the excited utterance exception. DM and BF are young female college students and the self-described scaredy cats of the house. They were awoken from sleep after a night of drinking, with DM reporting that she heard noises and saw a masked intruder in their home. None of the other roommates were responding to their calls and texts, further indicating something was amiss. It would be potentially terrifying for anyone, including these young women, to argue that they would have run out of the house or called someone else for help had they really been startled. Unempathetically ignores these circumstances and the trauma and confusion they were evidently experiencing, which likely offset logical thought. Indeed, the girls' fear and confusion is evident in their words, with both questioning what's going on. DM stating she was freaked out, scared, and confused, and BF attempting to get them together quickly for safety. They were clearly under stress and attempting to make sense of a frightening situation. Additionally, the time period that elapsed between what DM saw and her communications with BF about the same was a matter of minutes. The text message exchange lasts approximately 4 minutes, with the messages occurring in rapid succession. This timeline left no time for the reflection or fabrication, which is ultimately what IRE 8031 and 8032 seek to protect against. Consequently, the court concludes that the assertive text messages within this 4-minute period are likely admissible as present sense impressions and or excited utterances, assuming the requisite I can't say it. Can't say the end of it. I don't know why my mouth's not working. Foundation is provided at the time of trial. Maybe I need a breather. Welcome in, everybody. I've been on the other screen just reading away. So welcome in, everybody. It's good to see you guys. If you guys don't mind, take a second, hit the like button for your girl. I appreciate you guys being here. And let me put me down here. Okay. So we're on number 3. DM text to victims. So at 4:32:57, DM text Kaylee, please answer. The state argues this text is admissible as a present sense impression and an excited utterance. Defendant does not directly address the text. However, the court find it is more of a command or request than an assertion of fact. It is not a fact capable of being proved true or false, thus it is not barred by IER 801. At 10:23, DM text Madison asking, "Are you up?" And approximately an hour later, DM text Kaylee, "Are you up?" The state argues that foregoing texts are not hearsay because they will be introduced for the truth of the matter asserted. Alternatively, the state contends that they are present sense impressions because they represent a consistency and continuation of DM's text from the prior night. Defendant disputes that the exception applies, pointing out that DM had been awake and assessing social media before she sent the text. Again, the court does not find these texts to be assertions. They are inquiries, not declarative statements. Even if they were assertions, however, if the state intends to admit the statements to establish a timeline of events, they are not hearsay because they are not offered to establish their truth. Therefore, they are not barred by IER 801. DM's calls and texts to and from others. The state contends that the text between DM and her dad, the text between JM and the vandal alert are not hearsay because they will be offered simply to show a timeline for the morning and early afternoon. In addition, the state notes that the phone call from DM to EA is not a statement and therefore not hearsay. The court agrees and will allow the evidence for the purpose of a timeline if the requisite foundation is late. Verbal communications between BF and DM. The state next contends that it intends to ask DM and BF at trial about statements they made to each other on November 13th, 2022. It argues the testimony will likely replicate that provided by these witnesses at the grand jury proceedings. The state contends they are admissible under the present sense impression and or excited utterance exceptions. Defendant does not directly address the argument. Okay. To the extent DM and BF seek to testify about the content of the calls, texts, and conversations about what they perceived during the 4:30 timeframe, they could be potentially admissible under the exceptions cited by the state. However, the state must establish the foundational requirements for such proffered statements. The grand jury testimony does not appear to include any conversations between them after the 4:19 a.m. to 4:37 a.m. time frame, and the state has not pointed out any out. Thus, to the extent they testify to oral conversations they had after they woke up the next morning, the court will reserve ruling and consider any hearsay objections at that time. Okay. The 911 call. The state contends that the entirety of the 911 call should be admitted because the statements therein are either non-hearsay, not admitted for the truth of the matter asserted, or they are accepted from the hearsay rule as present sense impressions and or excited utterances. Defendant generally objects to its admission, but takes particular issue with 3 statements within the call. The court finds defendant's objections to these specific 3 statements well placed, but will allow the balance of the call because the statements are either not assertions, not admitted for their truth, and or are accepted from the rule as set forth in Exhibit B here too. So the initial statements, the 911 call begins with BF telling dispatch something is happening, something's happened in our house, and we don't know what. This statement falls squarely within the present sense impression exception given that BF was experiencing concern that something was wrong with their roommates and HJ had just instructed her to call 911 after walking through the house. Thereafter, BF attempts to provide dispatch with the address of the house before an unidentified female speaker takes the phone and provides the address and BF's phone number. This exchange is not offered for the truth of the matter asserted and therefore not barred by the hearsay rule. Okay, it says, and HJ had just instructed her to call 911 after walking through the house. So I wonder if he stopped at Xana's bedroom or if he walked up to the 3rd floor and checked Maddie's room. And then came down. I don't know. It says female, it says, one of our roommates who's passed out and she was drunk last night. She's not waking up. The state argues the statement is a present sense impression because the female speaker is describing the scene around her. However, as defendant points out, the roommate at issue in the statement is Xana. The only individuals who experienced/saw Xana unresponsive were DM, BF, and HJ. Thus, defendant contends the exception does not apply because the female speaker never saw Xana unresponsive and thus lacks firsthand knowledge of the information contained in the statement. The inquiry here turns up whether the event the female speaker is describing or explaining is Xana is unresponsive, as defendant contends, or whether it is more generally the scene unfolding at the house, i.e. that her friend saw Xana unresponsive. The female speaker did not personally perceive the former, but she did personally perceive the latter. When the words themselves are considered, it is clear the event being described is that Xana is unresponsive, not that the speaker's friend saw Xana unresponsive. In other words, she is relaying to 911 that her friends observed and relayed to her. Her statement is therefore outside her present sense impression and thus the exception. It says, thus the statement is not admissible under that exception. So I think they were going to take that part out. It says 3 female. Oh, and they saw some man in their house last night. Yeah, the state argues the statement is both a present sense impression and excited utterance because it is response to finding Xana unresponsive. Defendant responds that the statement references an event DM saw 8 hours prior to the 911 call and therefore is not contemporaneous. Defendant also points out that the female speaker does not have personal knowledge and is simply repeating what she was told by others. The court agrees that the present sense impression exception does not apply to the statement because the speaker is recounting what someone else perceived. Additionally, there is no contemporaneity since she is describing an event that occurred hours earlier. The excited utterance exception does not apply either. Instructive here, whereto Idaho Supreme Court considered whether the excited utterance exception applied to a 911 call made by a man after he found a woman screaming for help for her friend, whom she said had just been pistol whipped by a man who fled the scene. The 911 caller had not seen what happened, but relayed to dispatch what the victims told him about the incident. The court held that the district court erred the omitting the 911 caller's statements to dispatch as excited utterances because the caller's voice was calm and he had not experienced a startling event or condition. Here, likewise, the audio of the 911 call does not indicate that the speaker's normal reflective through process were rendered inoperative. Her voice sounds calm relative to BFs and DMs. Although a slight nervousness can be detected in her voice, she is not audibly crying or breathing heavily. In fact, the speaker took over speaking to dispatch because she was more composed than BF, who initiated the call. Further, the speaker did not personally see Xana unresponsive, nor did she see the man allegedly in the house. She is simply repeating what others had told her. So the statement does not provide insight into her own thought process. Consequently, the statement must be redacted. Then number 4, DM's attempts to explain events. After the female speaker cedes the phone to DM identifies herself and asks if she could tell dispatch what happened. Dispatch responds by asking what is going on and if someone is passed out. This exchange will not be offered for the truth of the matter asserted and therefore is not hearsay. However, DM then states, I really don't know, but pretty much at 4 a.m., the state argues this statement is a present sense impression and or excited utterance because DM is trying to explain to the dispatcher what she saw while under the current excitement of realizing that her roommate is not waking up and something could be wrong in the house. Defendant disagrees, noting the event. DM begins to describe what occurred 8 hours prior. He further argues it is not an excited utterance because she and BF had several hours to reflect on what she had seen and experienced at 4 a.m. I was like, thank you, Mary Beth. Thank you. And Lori Grant was gifted. And don't forget to hit the like button. It really helps your girl out. Defendant is correct and that the statement does not qualify as a present sense impression. While DM personally perceived the event, she was beginning to describe the contemporaneity aspect is missing. She is attempting to narrate an event she saw 8 hours earlier. The excited utterance exception does not apply either. While DM is in no doubt under the stress of excitement caused by realizing Xana is unresponsive, her reflexive thought processing appears intact. She is starting to draw connections between Xana being unresponsive and what she saw and heard 8 hours prior, something she had time to reflect upon. She does not launch spontaneously into what she saw at 4 a.m. Rather, she asked the dispatcher if she can explain what she saw. Based on this exchange, it is clear her powers of reflection are quite active, thus abiding the purpose behind the exception. The statement is therefore not admissible and must be redacted. Statements regarding Xana. Dispatch then instructs DM to find out if someone is passed out. DM appears to make statements to bystanders that they have to go check if Xana is passed out. This is not offered by the state for the truth of the matter and therefore not hearsay. DM then states that Xana is not waking up. HJ is heard stating Xana in the background. There are squarely present sense impressions because they are describing what the speakers are seeing. DM then responds to dispatch inquiry about Xana's age again, not offered for the truth of the matter asserted before HJ takes the phone and confirms that Xana is not breathing. This is also a present sense impression and also likely falls within IRE 8034. Statements after law enforcement arrived. Around the time HJ confirmed to dispatch that Xana was not breathing, law enforcement had arrived on scene. HJ can be heard telling DM, I need to talk to them. I need you to talk to them. I can't talk to them. I need you to talk to them. The court finds this admissible as either a present sense impression or excited utterance. HJ had just discovered Xana's body moments before. He is operating under the stress of his discovery and attempting to answer dispatch's questions. His statements describe his inability to speak to law enforcement at that moment and therefore are admissible. At that point, DM took the phone again and dispatch instructed her to get a defibrillator if one was available. DM asked dispatch to repeat the question and stated, there's a police here right now. After dispatch repeated the question, DM indicated that they did not have a defibrillator and asked the responding officer if he did. The officer responded affirmatively, after which dispatch indicated she was going to let the officer take over and ended the call. To the extent the state seeks to admit the statements by DM for the truth, they qualify as present sense impression as DM is explaining the events as they are happening. They also are likely admissible under the IRE 8034 insofar that they regard the defibrillator. Finally, many of the statements are not assertions and thus not hearsay. Number 7 is crying, breathing heavy is non-hearsay. Apart from the statements the state Also moves for omission of the audible crying, breathing, and heaving made by the 911 callers. Defendant does not address the argument, and the court finds it well placed. While assertive conduct can qualify as hearsay, non-assertive conduct does not. Just want to make sure we're not like, okay, so there is no indication in the 911 call that the speakers are intending to make an assertion through their crying and heavy breathing. It is clearly an involuntary emotional response to the circumstances. Further, it is relative to show the stress and emotional impact the girls are under, which puts the call into context, thus it is admissible. The 911 or the transcript of the 911 call will be allowed as demonstrative evidence. So the final issue is whether to allow the jury to view the official transcript of the 911 call while listening to the call. Defendant contends it would be cumulative and asks that either the call or the transcript be allowed, but not both. The court views this issue as essentially a request for use of the transcript as a demonstrative aid. A demonstrative exhibit is relevant, if it supplements the testimony of the witness or assists the jury in obtaining a better understanding of facts and issue. Transcripts are widely used as demonstrative aids to help the jury understand the contents of audio recordings. When used in this way, courts will typically instruct the jury that the transcript is not evidence independent of the audio recording, and if the jury determines that the transcript is correct, it should disregard it to the extent and rely on its own interpretation of the audio recording. In addition, the transcript must be authenticated by showing that it fully and accurately complies with the audio recording. Against this background, the court will permit a transcript of the 911 call to be used as a demonstrative aid, assuming the proper foundation for a 911 call is established and the transcript is properly authenticated. To this end, the state is responsible for proposing an appropriate jury instruction. The transcript will not be admitted as substantive evidence and will not be available to the jury except when the 911 call is being played, including during deliberations. Because it is not going to be used as evidence, the court does not find that the transcript is cumulative to the 911 audio or otherwise prejudicial to defendant. And then the order here is based on the foregoing, the state's motion of limine, text messages and testimony is granted in part, reserved in part. The state's motion in limine, the 911 call is granted in part and denied in part and reserved in part. And that's because they redacted and they took some stuff out and they added some in, it sounds like. So I think this is the phone activity. And I think that we went through these before, but we might as well just go through them really quick, just in case they did switch some stuff up. So you're going to see here the time. This is all on 11:13 at the beginning. The record will show what the phone was used to do, and then the ruling. So I'm not going to go over the rulings. I'll let you read those, but I will go over the time and then we'll go over the record. So 2:10:29, DM to Uber driver inquiring if he was driving. 2:13, Uber driver to DM confirming he was driving. 2:53 a.m., Madison Mogan calls Bethany Funk. So at 2:53 a.m., when they're in their mix of calling, people are calling each other, Maddie calls BF. So I'm not sure what that was, that phone call was, but I'd like to know. So then at 3:51:03, DM creates a new contact in her phone. At 4:19, BF calls DM for 23 seconds. And 23 seconds is a pretty long time. DM calls, and then at 4:20, DM calls Xana Kernodle. At 4:20, DM calls Kayla Gonzalez. At 4:20, DM calls BF for 41 seconds. At 4:21, BF calls Xana. At 4:21, DM calls Maddie. 4:22, BF calls Ethan. 4:22, DM to BF, no one is answering. 4:22, DM to BF, I'm really confused right now. 4:22, DM to Kaylee, and then 4:22, DM to Kaylee, what's going on? 4:23 a.m., BF outgoing message to Snapchat. 4:23, BF to DM, yeah dude, WTF. 4:23, BF to DM, Xana was wearing all black. 42333 DM to BF. I'm freaking out right now. 423 DM to BF. No, it's like a ski mask almost. 423 BF to DM STFU. 423 BF to DM actually. Like you could see how these girls are scared. I mean, they're not even waiting a second to write each other back. Like, I mean, it's literally within seconds. Like DM to BF, like he had something over his head and a little and mouth. DM to BF, Bethany, no, I'm not kidding. I think this is supposed to be, I am so freaked out. And that was at 424, 42407, BF to DM. So am I. 42411, DM to BF. Phone is going to die. Fuck. 42414, BF to DM. Come to my room. 42422, BF to DM. Run. 42427, BF to DM. Down here. 42439, Dylan calls Ethan. 42458, DM to BF. I'm scared though. And then 42516, BF to DM. Yeah, I know, but it's better than being alone. 427 DM outgoing call. 427 DM outgoing message and a Snapchat. 427 DM outgoing message Snapchat. 427 DM calls Kaylee. 428 DM calls Lana. 429 BF calls Maddie. 430 BF calls Maddie. 430 BF calls Kaylee. 431 BF calls Kaylee. 432 DM text Kaylee, please answer. 434 BF assessed Snapchat. 437 BF assessed Instagram. At 10 a.m. to 10:23 a.m., DM assessed social media, messaged on Snapchat. At 10:23, DM to Madison, are you up? 10:24 to 11:29, DM assess social media, message on Snapchat. And then DM to Kaylee, are you up? 11:29, DM accessed social media, message on Snapchat. 11:39, DM and dad exchange text. 11:40, BF phone call to JM. 11:50, JM to DM, bro. 11:50, BF phone call to EA. 11:51, GM to DM. Do you guys need me to come get you? I don't know who JM is. Wonder what her dad's name is. Like if that could be her. No, because they wouldn't say bro. Never mind. So DM receives vandal alert, and that's at 104. I believe that's all. This is going to be the 911 call. We won't go back through that again since we already went through it once. Okay. I was just making sure there's nothing in here that, just making sure there's like, it's all the same. And this should be all of it. Okay. So, the next one, I'm going to actually not read through the document, but because we have 3 documents altogether. I'm going to let Nancy take it away. I saw this earlier and I was like, huh. So I'm going to let you know what the document says, but it has to go over the autism spectrum disorder. So you know how they were trying to strike the death penalty off of the record because Bryan Kohberger apparently has, the type 1, like ASD. He has like the lowest version of it. Well, they had 2 doctors, I guess, analyze him. And I'm trying to get to the bottom page so I can read you what he says. So the order, based on the foregoing, defendant's motion to strike the death penalty for the autism spectrum disorder is denied. So Bryan Kohberger, sorry, buddy, you can't use it. Hey, Machachi, you can't use it. Hey, Christine. That's funny, Squeaky. Why'd I have to be the girlfriend, though? I want to be the wife. Man. Hey, she wears funny hats. I like that. That's a cute name. Okay. They just did this video 2 days ago. I didn't even know about it. So we're gonna watch over this and see what her and it's Nancy Grace. It's a twofer here. Okay, we got Megyn Kelly and Nancy Grace. And if you would have told me these two women were about the same age, I would say you're lying. But apparently they are. Didn't know that. Thank you for being here. And she actually goes over and she talks to her about the Ellen Greenberg case too. So I'm sure that's a really good episode to listen to as well. So I'm going to go ahead and I'm going to play this. And then the next document that we have left is just order on defendant's motion in Lemmy, vague and undisclosed expert testimony. So we'll see what that has to do with. Hey, Trips True Talk. Hey, CJK, welcome in. Thanks, Be Happy, for gifting out 5 memberships. It's very kind of you. And I can't believe they're actually giving us some more info, you know? I'm pretty excited about that. Okay, I'm gonna go ahead and hit the play here and we will listen to what they have to say.
Now is set for trial this August, finally, after all these years of delay and some strange motions being filed, I think, by the defense, so far without success in recent days. First, defense attorneys for Kohberger asked the judge, Hippler, 2 P's, you say it fast, it could be confused for another name. Judge Hippler was not impressed with the motion to disallow any reference to the bushy eyebrows, that his defense attorneys didn't want the roommate's description before she knew who Bryan Kohberger was. When she was just describing the intruder, she saw he was wearing a mask, but recognized his bushy eyebrows. The judge has said that will not be barred. That's a matter for cross-examination. Secondly, the defense wanted to bring up that he's on the autism spectrum in opening so that it might explain away what they suggested were some of his odd behaviors, perhaps during the hearing or during the trial. And the judge said, you're not bringing that in. You can, if you want to put him on the stand and talk about him being on the spectrum, great. But you can't just offer testimony as the lawyers in order to explain away either his behavior in the court or any other behavior in this case. And they also asked him if they could call an expert to talk about his alleged OCD, because they said prosecutors may make arguments that Kohberger was destroying evidence right before law enforcement arrested him. And so they wanted to get around having him testify by having an expert take the stand and say, that's his OCD, because I guess everybody who's got OCD puts all of their garbage in little Ziploc baggies and then has the garbage disposed of in the neighbor's trash. But this is defense attorney Ann Taylor doing whatever she can to zealously represent her client. So what do you make of, what does all that tell you about where this case is for the defense, first of all?
It tells me, Megan, that they're between a rock and a hard spot. Now, the judge has ruled that they may not bring in evidence of alleged autism on Kohberger's behalf in the case in chief. This is a death penalty case. It is a bifurcated trial split in 2. First, there's the guilt-innocence phase, and if he is found guilty, which I predict he will be, there is in the second phase of the trial, which is the sentencing phase, where the jury will decide whether he gets the death penalty. Now, regarding autism, the defense wanted to bring in their theory that he has autism, although apparently none of the defense experts have stated thus far that he is autistic or under the spectrum. None of them have said that. They said they wanted to bring it in, as you surmised, because of his odd behavior. What odd behavior, the judge says? I don't see any odd behavior. He just sits there. So, therefore, that's irrelevant. If it becomes relevant, then I will review your motion again if you choose to renew it. But as of right now, the only way it would be relevant is if they noted quirky or odd behavior when he takes a stand. So if you want to bring it in then, sure, but he'll have to take the stand, because just sitting there, I don't see any relevance. However, if there is a guilty verdict and it goes to sentencing, I believe the judge will relent and bring in, if there is any expert that says he is autistic, to diminish his capacity to commit a crime. Now, will it diminish his capacity to commit a crime? No, that's a big no. Why? This guy is a PhD student. He has made stellar grades. He is actually teaching other students. He is not going to be deemed incapable or incompetent to commit a crime. In fact, he was obsessed with committing crimes. You know about the questionnaires he would send violent felons when under the guise of studying criminology. How did you feel right before you did it? How did you pick your victim? How did you make your exit? In other words, how can I get out of this without getting caught? They're between a rock and a hard spot. Bryan Kohberger's DNA is on the knife sheath in the snap button where you put the knife in and you snap the sheath shut under a dead body. So again, rock and a hard spot. That's where they are.
Howard Bloom, who's been all over the reporting on this case, reports that Kohberger's mother, Marianne, his reporting is that she's encouraging her son to plead not guilty, notwithstanding all this evidence, and that there might even be a movement afoot by Kohberger's defense attorneys to somehow wrest the decision to stay in the not guilty camp away from Marianne and Bryan as we get to the trial, and somehow convince this judge to let them enter into some sort of a plea bargain negotiation with the prosecution. That Bryan Kohberger is apparently not capable potentially of making this decision, that the mother's overly influential, and that Ann Taylor, as defense attorney, probably knows better about what's going to happen at this trial. There's no world in which Ann Taylor can cut a deal for him without his consent, right?
No world. No world. As far as a guilty or not guilty, no. As far as a not guilty by reason of insanity, which he's not insane, guilty but mentally ill, he's not mentally ill. There's no way that she can usurp his ability to enter a plea, either guilty or not guilty, or an Alford, which is I accept my sentence, but I'm not going to say I did it. I don't know, frankly, if the state would even go along with a guilty plea for life without parole. I'm not sure that they would do that. They are hell-bent on seeking the death penalty, and he's not going to plead guilty to the death penalty. To me, that means you're going to trial. Now, there is a way that the judge could enter a blind plea, which is there's no recommendation by the state, but I don't think they would do that either, because what if the judge said, okay, yeah, I'll take your guilty plea. You're getting the death penalty. So I don't think there's going to be a blind plea. Ann Taylor cannot plead in his behalf without his consent. So with the mother trying to convince him to stick with the not guilty, according to Bloom, who's written a book about the case, that is undue influence on the son, where the defense attorney wants to enter a guilty plea.
Tara Forrest,
So wouldn't you think that his mom would be saying, like, try to take a plea deal? She's like so against the death penalty before all this. Like before this case, remember she wrote that thing about like the death penalty and like how she was against it? Ugh. Is your light counter not working? We are at 79. Mhm. Yeah, the state of Idaho, they do want the death penalty. Now, I have been saying, I think since the beginning, he might try it, he might not. But I think once we get closer to court or trial, he sees the evidence. I mean, Bryan, if he's did this, he knows what's against him or what's not. Whether he wants to take that, at trial and try to go to trial and, beat it. That's another thing. I don't know if he'll be able to beat it. We've seen the evidence so far, and in my opinion, I think that it's pretty heavy. I don't think that everybody in America is freaking innocent of the crimes that they've committed. I mean, we've got like 4 right now that are going on that people are saying people are innocent. It's like, not everybody can be innocent. Yeah, me too, DM. I think so too. She was a school teacher, like a guidance counselor or something like along those lines. Yeah. Yeah, they brought back the firing squad. Yeah, they sure did. They sure did. So I wanted to. I'm debating on whether to go over this one. Like, I don't think this one is that important, like for us to read. But I did want to go over. Okay, okay, it was this one I wanted to go over. Okay, so a judge ruled Thursday that prosecutors could seek the death penalty against Bryan Kohberger if he is found guilty of the 2022 slayings of 4 University of Idaho students. Judge Stephen Hippler issued his decision after Kohberger's attorneys asked the court to bar the sentence due to his autism diagnosis. Prosecutors previously indicated in court filings they intended to seek the death penalty with the conviction. Defense attorneys in court documents argued Kohberger's autism spectrum disorder reduces his culpability, negates the retributive, I can't even say it, and deterrent purposes. I cannot read tonight, y'all. I can't get the words to come out of my mouth. Purposes of capital punishment, and exposes him to the unacceptable risk that he will be wrongfully convicted and sentenced to death, according to a report from the Associated Press. And I also want to try to find where his mom was talking about him to stay in the not guilty camp. They added it could be considered cruel and unusual punishment, which is outlawed by the 8th Amendment to the U.S. Constitution. Hippler and Kohberger's attorneys failed to show that ASD is equivalent to an intellectual disability for death penalty exemption purposes, and there is no national consensus against subjecting individuals with ASD to capital punishment. And he also, he has like 119 IQ. ASD may be a mitigating factor to be weighed against the aggravating factors in determining if defendants should receive the death penalty, but is not a death penalty disqualifier, Hippler said. The 30-year-old is charged with 4 counts of first-degree murder in the deaths of Madison Mogan, 21, Kayla Gonsalves, 21, Xander Kernodle, 20, and Ethan Chapin, 20, who were stabbed to death in an off-campus home in Moscow, Idaho, at about 4 a.m. on November 13th, 2022. Authorities have noticed suspicious behavior, like Kohberger allegedly turning off his phone before driving home and changing his license plates days after the killings. However, authorities claim to have a key piece of evidence saying they found Kohberger's DNA on a knife sheath found under Mogan's body. The former criminology PhD student is also charged with felony burglary. A judge entered not guilty pleas in May 2023, though the trial is not expected to begin until August 11th. Well, we will be watching it. We will be watching it. Oh, I thought this was on here, but it didn't. I just read that to you and it didn't even come up. It didn't even switch to the page, so that's okay. That's fine. That's fine. But I'll play this video here. It's just like, I think it's going to tell us. Yeah, okay.
New order on quadruple murder suspect Bryan Kohberger's bid to have his family guaranteed courtroom seating. Chanley Painter is here with all of the details on this. Good morning, Chanley.
Hey, good morning, Carly. So the accused mass murderer, Bryan Kohberger, wants his family sitting behind him in the courtroom during his upcoming trial. However, prosecutors are planning to call his family as witnesses in their case, and typically potential witnesses are not allowed to sit inside the courtroom before they testify, so they aren't influenced by what other witness may tell the jury. So Kohberger claims this violates his right to a fair trial. The 30-year-old former criminology student faces a potential death sentence if convicted for the stabbing deaths of 4 University of Idaho students in 2022. Kohberger was arrested more than a month later while at his family's home in Pennsylvania after authorities say they found his DNA on a K-bar knife sheath left at the Idaho crime scene. Well, now Kohberger is asking the judge for guaranteed seating inside the courtroom for his
Good
parents
luck.
and 2 sisters who, according to his attorney, have no interest in cooperating with the state as witnesses for their case. And before the judge makes his decision, though, he's requiring prosecutors to name the exact family members they plan to call and explain why they will testify and why those family members could not be called at the start of the trial, which would then allow them to be able to sit inside the courtroom very early on in the case. Well, the judge said he would try to strike a balance between both of these sides here. Prosecutors must send him that information by next Friday, and he will make his final decision May 15th. Carly.
Oh,
Chanley Painter
May
live.
15th. May 15th. Okay, well, we'll remember that, May 15th. We'll be waiting on that. I was gonna say that too, like, if I was gonna ask you guys if you would, if you would say, I'm not working with the prosecution. I wouldn't be able to do not help. You know what I mean? Like I'd be like, that's my child. I don't want anything bad to happen to my child, but at least I have my child at the same time. You know what I mean? When he's not a child at all either. And Chanley Painter, that girl I can't believe they fired her off Court TV or whatever. I'm so glad she's over here at Fox News. She looks good. She's still working the case. And I love that. Remember she was at Court TV? And she did all the Idaho content for them. And then they just got rid of her. And then they picked her up over at Fox. I forget exactly why she left or what happened. She wrote it on her Twitter, though. I remember that. Speaking of which, we'll go over there real quick and we'll see if there's anything going on. Tomorrow on our live, we're going to watch the interview that we're going to get back into the interviews with the Gonzalez family. We started covering them a couple nights ago. So this will be part 3 tomorrow. I think we'll probably only watch one video or 2 videos actually, because I found one that was from December 3rd. And I didn't know that, or January 3rd. Actually, that works out perfect. Okay. That's where we're at. So January 3rd will be the first one. And then the second video is going to be the one that Olivia did, Chronicles of Olivia did with the Gonzalez family. And it's like a 48-minute video. And they did that on January the 13th. So we'll cover those 2 tomorrow. And then I'll try to get a bunch of them for us out. Hey, Delana. Is it Delana or Delana? Delana, I bet. Either way, it's pretty. Oh, did she? Oh, yeah, she did do Johnny Depp because they have a picture of her in there. And she was wearing like this like neonish green outfit or something. She was looking good. She was looking good. Oh, thank you. The long okay. Someone said my name, was it yesterday? They're like or Tanya, and then they're like Tanya. I mean Tanya. I'm like, no, it was right the first time. You had it right the first time. I was like, thank you. Okay, so I think that's all I really have for you. Let me check, see if there's anything over here on Twitter about Bryan, Let's see what we can find. Let's go to the latest, because some of this stuff is pretty entertaining. Like, some of the people over there. Like, a lot of people are going back to the beginning, and they're like, we're going back to the beginning, but we're looking at documents and stuff. We're not going back and, like, saying that Jack DeCore did this. Like, it's like they're going back to the beginning and blaming people they blamed in the beginning of this case. And I'm just like, wow. I might have to put out that video that I did with all of it had, like, all the suspects that were, like, throughout this whole case. There was, I think it's like 37 or something like that on that video that I did. I might have to put that back out. It just says that the judge rules death penalty will remain as possible punishment. So no one's really touched the document that we first talked about, with the redactions and stuff. And that's the one that has a lot of the information in it. So we'll have to see if they go over that. If BK purchases sheath as a replacement, would that mean prosecutors have the K-bar knife they believe was used? I can't call it a murder weapon. I don't think so, Digital. I think it's because they know what kind of knife it is because of the sheath that was found under Maddie Mogan's body. the sheath had the USMC logo stamp on it, and I think that they just matched that sheath to that knife. Yeah, my heart goes out to all the families. I've cried more tears for these 4 kids than I think any victims that we've had, because it's just been going on for so long. And it's just been just ever. I mean, the vigil got me. I remember watching that on another person's channel, and I'm glad I turned my camera off the whole time. My camera was not on that whole time. Like, I was like, I'm just gonna sit over here and cry. It was like seeing like Maddie's boyfriend go up, like those of like Maddie's father go up, like, some of them people just they all of them, all the family members. But when some of the families, like Maddie's mom, she's only spoke once. Like that was like, I was like, oh my gosh, like I was all ears wanted to hear what she had to say, because we didn't get to hear from her. Let's see if the Gonzalez family has said anything. What is this? It's in memory. I don't know if I could play it. I mean, I don't see. Okay, so this is it's a song somebody made for Steve and all them, and it says, a song for Steve Gonzalez in memory of Kaylee Gonzalez. Oh, and it's a song. Find a field, I'll tear it up till the pain's just a cloud of dust. Oh, those are. Oh. Yeah, sometimes I drive your truck. Oh. I bet I could play it because, but I'm going to put it in the chat for you guys just in case. So if you guys want to go listen to it after this, you can. I bet it's sad. I bet it's music. I mean, I can't do sad music. I can't do sad songs. It gets me. Kaylee J Day is coming up, and it's going to be on June 8th, her birthday. Does this have music too? Probably. Oh, no. I mean, it does, but I don't see it. Okay. Let's see if there's anything else. Yesterday at 12:12 a.m. Christy's just up looking at pictures. It's so sad. These were the pictures that she posted. That's so sad. And then Valentine's Day. Okay. Man. So we will get back to doing the interviews tomorrow. And yeah. They probably could, Jenna, I would say, especially if like maybe I'm trying to think of a way to put this. If it like went through like a bone, I know that's bad to say, but like maybe the striation marks, like what it, but yeah. Steve part 3, yeah. And it's gonna be a good one. We have some stuff coming out, and today's Thursday, so we might have more documents tomorrow. You never know. Judge Hippler might be feeling a little generous, but if not, we'll make sure that we play the 2 videos that I have ready for us. And then I think there was something else. Maybe not. I have 3 folders that are like that I have probably 20 to 30 tabs open just for this case to go over, like stuff to go over. I just got to pick a tab and just go with it. Whatever night we want to, cover it. There are some other true crime. I'm trying to think. There are like true crime updates. I couldn't get that word out of my mouth. What I wanted to tell you guys. Let me see if I can pull it up. I saw this today and I was like, holy camole. I thought this was awesome. So, Rex Huerman. You sick son of a bitch. We have an identification, another identification of Miss Peaches. I'm just trying to find the picture of her and her baby. So, okay, I hate when they do that. I don't want to create a free account. Okay. Here it is. Here's the picture. So if you guys aren't following the Gilgo Beach serial killer, we've been covering that on this channel, and look what her name is, Would you look at that? I don't know if she goes by Tanya or Tanya, but Peaches has now been linked to a 1991 Geostorm. That's her tattoo, of course. Her name's Tanya Jackson. And Tatiana Dykes is her little girl that was 2 years old that they found her remains. So, trying to see when we'll have to go over it and see how they identified her, but it was through IGG. It was an Army veteran. She was an Army veteran, so she wasn't a worker? She's only 26. Okay. Through DNA, they didn't know their identities. Oh, there it is. Yep. They ultimately identifying the victims through investigative genetic genealogy. And now they have their names back. I mean, in June of 1997, that's when they were found. That's when she was found. But April 11th or April of 2011 that's when they found her daughter. They found her daughter like further away than from her. But yeah, I saw that and I was like, man, wanted to give you guys that update. And there's some more updates I want to give you guys, and then we're gonna go over I think we'll do like a case update show. And then is there any other updates in any of the cases that we're covering? I'm like asking you guys, like, I don't want to forget anything. I've been wanting to look up like all the cases that we cover, like Elijah Vu, all the cases that we're waiting on a court hearing to happen. Yeah, we're still waiting. What's this? June 20th. Jesse Vang goes back to court. So we'll be there. But yeah. So no, the chat isn't deleted. So what happens is it takes a minute for the live chat to come up. So yeah, we have to go in every night and we have to actually physically put in the live chat. It should be. It just usually takes like, I don't know, 30, 45 minutes to load, something like that. So yeah, whenever you come back, you can yeah. Oh, PJs, I don't know if I let my daughter even go, I mean, you have to, but he's the one, yeah, baby girl. He's the one that's being charged with Elijah Vu, him and the mom, Katrina Barr. There's more. I know there's more cases. I just need to go to our stream thing, my content, my videos, and see what we've been missing some cases. I know we have. But I know that Rex Huerman had like an update. There was just like a few updates in some not smaller cases, but other cases that we're covering. And we're not doing. It seems like a lot of people went to court or they're in the process of going to court. You know what I mean? Like, which it's like, come on, guys, let's get this going. Diddy, we haven't done Diddy in a while. Maybe I'll have to go back over and see what he's up to because he's a whole mess. Who's still in jail? Oh, yeah, she's still in jail. Yeah. Yeah, they're both in jail. Oh, thank you, Mary Beth, for gifting the membership. Digital Maniac got it. There are some court trials this summer, and we've got, all I know is we have Bryan Kohberger August 11th. And as far as I'm concerned, we are all just going to have a great summer. You know what I mean? Like, great summer. That's what's going to happen. Oh, you're watching the Karen Reed trial? So I asked people, I don't know, I tested the waters with the Karen Reed content over here, and nobody really cared to talk about it. I'm pretty into it. I'm pretty interested because I mean, I think she did it. I'm sorry. I think she hit him. I think she did. That's just my personal opinion. But I do like to talk about it, and I like to get both points of view, like for that case. But I did, if you guys are interested, Fox Nation came out with a 2-part series. If you want to watch it, I have it on my playlist. And then they didn't do any more after that. And then let me see, because I know, like, because I did like a poll, and like the amount of people that voted or something on it at the time, what wouldn't like suffice, being like covering it. Now there are people that are covering it that are like doing awesome, like Emily DeBaker. There's a few lawyers that are covering that trial actually that are doing a really good job. But then you have like other people that are really good, like true crime creators covering it, and they have like 20 people in their chat. And 8 hours a day. I mean, that math ain't mathing at all. So it's just like, I don't know. We might have to do like nightly recaps though. I like, because I've been like looking all over this stuff. So okay. Trips, you sound like me. Yesterday I went off on the chat. Not on the chat, but it was one person. But they're like, Kohberger's innocent. And I'm just like, is everybody innocent? I'm like, so we've got Delphi, Richard Allen, he's innocent. We've got Karen Reed, she's innocent, right? We've got Bryan Kohberger, he's innocent. Is Lori Vallow innocent too? Like, who's guilty? Stearns, is he innocent too? I'm surprised no one said Stearns. I think they all know better than to say he's innocent. Hey, Smelly Story of True Crime. I thought that they stopped at lunch today. I saw that because it looked like only people were streaming for a few hours. I wonder why. Did something happen? I know her text messages are coming in. Yeah, baby girl, there are. See, I don't see dog bites there at all. I see car. I see a headlight. That to me, that looks like something that would happen in a car accident. But I don't know. And just, I don't know, because cops put evidence in solo cups. Well, I mean, I can't really blame them for that. It was a snowstorm, right? And they're trying to collect evidence before it like is gone. I don't know. I just think that I think she got pissed. I don't think she really meant to kill him. I don't think she meant to kill him. I don't think she meant to do that. Don't think she meant to do that. But I think she had some drinks. He wanted to go over there and hang out. She probably was upset because she didn't want to go hang out. I don't freaking know. But all I know is I can just tell you, I can know when I can know when a woman is pissed. And that woman, she's pissed. She's like real angry. You know what I mean? Like she's angry. Like she's smiling, but she's not. Like you could tell in her eyes. Like she's like burning you with her eyes. Like scares the piss out of me. I wouldn't mess with her. It might change my mind, but I doubt it. I don't know. I'm really stubborn when it comes to that case. From what I've seen and I've heard of, and I mean, she backs into the damn car and she says she didn't. If That ain't some coincidences. I don't know. And then what she said to the kids, how she treated I don't know. But I don't think that people should be acting the way they are acting towards John O'Keefe and his family. I think it's disgusting. And I think people that are like that, if that is what gets you going and gets you yeah, that's cool. Then I'm not the place for you. And I'm not the girl for you, because they literally have treated them like straight shit. So, yeah, when Adele screamed corruption, they're corrupt. Corruption everywhere. It's weird though that she's talking to Turtle Boy, and he's got 16 charges for witness intimidation. You don't think that she had him do that? You don't think she had him do that? Come on now, Turtle Boy. If you are a grown-ass man and you are going by the name of Turtle Boy, get the F out of here. Get out of here. Get out of here. Get out of here with that. I mean, I know my name is TitaniumBuilt. Okay? I'm not going, but I don't go around talking to myself in the third person saying TitaniumBuilt said, TitaniumBuilt did. Yeah, and they're bringing her conversations from Dateline or whatever in, aren't they? Oh, do you remember when that happened? When Turtle Boy first came out with the Karen Reed thing? And did you guys watch that Dolly episode? Dolly did? I never laughed so hard in my life. I've never watched a full Dolly live, but that one I did. And I laughed the whole time. He was like, I'm the only turtle anything around here. And I just laughed. I don't know. I just thought that was pretty funny. Sorry, new interview. I don't know. CJK, I don't think so. I don't think there's a new interview with him. Yeah, Dolly had me laughing. He was talking about him and somebody else with the Karen Reed thing, and it just made me laugh. I mean, you know. I think that Turtle Boy might have a thing for Karen Reed. I don't know. Didn't he get in trouble for beating his girlfriend up or something though? Beating his wife up? I don't know. I don't want to start that rumor, but yeah, I'm cool over here. Maybe I'll watch the rest of the trial and I'll watch last trial. Yeah, no, he is. He's Turtle. He's like Turtle something or other. I don't know. He's the Turtle commander. I don't know what he is, but he does watch, Turtle stuff. Oh, it's just not worth. I wouldn't have enough people, Ladybug, to stream it. To even literally to heat the place and light the place. I wouldn't get enough people in here. Because I haven't been following the cases much. Do you know what I mean? Hey, Christine. Or thanks, Christine. Hello, Christine. Hello, Christine. Even though we've been talking for the last 20 minutes about this case. Thank you for gifting 5 memberships. I'm reading and I'm trying to talk at the same time. That's not good. Don't let me do that. But I could probably do some night recaps or something. Oh yeah, he did, baby girl, try to do that. Or was that him? Or what? Oh, that was Tom CPU. Okay, yep, that makes sense. I was I remember them. I remember Dolly being out there, and I remember it being a thing. That Tom CPU, man. He's something else, isn't he? He's something else. They all are. I mean, she wanted a show, and she got one, Now, if Karen Reed didn't look like Karen Reed, if she was a little scarier looking, a little rougher around the edges, we'll say, I bet you there wouldn't be this many people riding for her. It's her looks, a lot of it. I'm going to say 90% of it. I'm not even lying. If she looked like she was like a scarier person, people would be like, guilty, she's guilty, she did it. And she's got a lot of money and she's got a mouth. She ain't afraid to run it. Like, she's not afraid to speak. You know what I mean? Like, she's not like timid or anything, which I mean, I would be. I'd be timid. I would have probably like, shit, I probably would have taken a deal. I probably would have taken the deal. Deal or no deal, deal me in. That's what I would have said. But who knows? Who knows? But there are a lot of cases going on right now. So, I mean, what else is going on? Lori Vallow just stopped. That's the other one. So, shoot. I forgot about that one. Guilty, you know. Let's see if there's anybody that's live I could send you guys over to. Maybe there is a new one. Let's see. So it looks like that Drunk Turkey did an interview maybe with Steve tonight. Yeah. I think he's live right actually, yeah. I don't ever watch his channel because I don't know why. I just never I don't get the notifications because I'm not subscribed. I should subscribe. Maybe, you know what? I'm gonna go do that right now. I'm gonna do that right now. That way, I can at least say that I have one person that covers this case that I could watch because I don't watch anybody at all. Like 0 creators that cover Idaho 4, unless you can think of one that I don't think I do, which is weird because I used to like watch a lot of true crime, but there's just none. Oh, is he finishing up now? Yeah, she's been working the Lori Vallow case for a while. They did, baby girl. All the channels went bonkers in the Sebastian case. Yeah. Yeah, I literally I don't know how long it's been since we've covered that case. 2 months? 3 months? It's been a while, and it was, I mean, my good golly. I don't know how I don't I'm just thankful that I don't no one tells me what to do over here. I don't know. I just love that. I think a lot of people are PJ's second chance. I think a lot of people are. Yeah, I knew the Sirius Black mods for him, yeah. Yeah, she's modded for him since before I think she even came into our chat. You mod for True Crime Lullabies, don't you? I saw that she had some mods from over here. Yeah, same old drama. They just go back and forth. Like they're reviewing a review of a review of a review of a review of them. I don't know. I wonder what will happen with the lawsuits. I hope something happens. I mean, I really do. I hope, because there's a lot of people that are really fudging with people's real life. Like, the reason why I started covering Sebastian was because one of the subscribers asked me to. Nobody was covering his case. We started covering it March 3rd, and I didn't know Duchess did the interview March 3rd with the parent, with the Chris and Katie, and Trev Time was on it, and he was doing daily like updates. And I remember going, okay, cool, because I would go to his page so that I could remember what day we were on, because I mean, my brain sometimes it would be like, is this 22nd day or 23rd day, or you know what I mean? So I'd go to his page and I knew it was always right. Same review, different day. Yeah. Yeah. So it's just crazy. I think he's in the woods somewhere. Yeah, they won the anti-slap. I just wonder if they'll get like any, like I want to see the money. You know, not for barbecue, not her, but um, I do want to see BJ have to pay Granny some money. I'm not gonna lie about that because of all the stuff that I've seen. Like, man, like you can't go people's real life and then say that they're going in your real life when they haven't been. Because I've been watching, I've been listening. I'm a observer. I observe. Sometimes you'll see me in the chats. I ain't gonna lie, because sometimes I will straight be all up in that chat. Like I'll be with my with my one hand. But I did hear some of Granny's live today. She had put it on members only. I don't know if it was members only or if she put it on there afterwards, but I think she deserves it. I think she deserves, yeah, because she really did. She really did shut her mouth. Granny wasn't talking. She might have said like I do with BJ, like here and there, maybe like a little something, like one little thing, and that's it. Do you know what I mean? And we keep it moving. But it was like every night. I mean, she's probably live right now talking about her. Let's see. I'm just curious. Don't bow to the hate mob. Well, she's late. She's supposed to be live a long time ago. Well, not a long time ago, but 10:45, and I thought that she was supposed to go live. I don't know. Maybe what's his name had her go live. Tony, I didn't see that. I don't know if you guys watched that shit show, but apparently Tony had to do some cleaning up. I don't know. Ministry, that's why your name was so familiar. I bet that's why, because I'm like, Ministry of Defense, Ministry of Defense. I'm like, I know that Ministry of Defense, like I know what it is, but like I think that I think I saw you when you were over there with her as a mod. I went to Brittany's channel for a long time. Not a long time. Like a couple years. I mean, but that ain't the girl that I knew. You know what I mean? Like I knew her for a couple years. I talked to her on the phone here and there, not a lot. Maybe 4 times, 5 times, you know what I mean? Not a lot, but enough to have a baseline of know her personality. And she wasn't sleeping. Oh, you modded under a different name? I was like, Ministry, I know your name from somewhere. Maybe it's from another chat, but I know it's not just from this chat. That's what I'm trying to say. Yeah, I guess Tony went up on Brittany's panel or something. I just saw the like the thumbnail. I can't watch unless like someone clips her. And Hartley, it does the best clips that I've like so far. Like they're just hilarious. What name did you mod under? Now I'm wondering. Because I know I probably know who you are. Because I mean, man, she's had a lot. She's had a lot of mods. Oh man, they go in drones. I mean, at some point you probably like would run out of people, right? That's why I mean, I only like it's not like I mean, that's not why I don't mod in a lot of people, but that is kind of why I don't have a lot of mods because you don't really need a lot of mods, especially if you have no one in your channel. If you know what I mean, like most nights, if my mods want to take a night off, I think I'd be okay. Actually, I don't think I would. I lied. I need you guys. No, but if you guys want to take a night off, you guys totally could. But you guys do help me out so much. There was how many? Oh gosh. Yeah, so the Julie thing, yeah. I have to go back to watch that. 9mm lipstick. Okay, I remember. I remember the 9mm lipstick. I remember that name. Well, Julie was never, I don't think, a part of it. And she was going to like go and like tell like that Tony did all this stuff, I guess. She was going to dig on him. Could you imagine having a channel that you work your whole life, like for the last 5 years or something, 3 years, and you work day in and day out, and then someone calls you, and not only do you have to answer the phone because you signed like an NDA or something, but you also have to go live because they want to use your panel. I'd be like, shit, I'm taking a nap. I know. Well, I want to know what there is too. Oh, it's okay. No, I stopped going there last Christmas. Not this past Christmas. a year and a half ago now, or whatever. Because she just one last lie. It was just one last lie, and I said, if she lies again, I said, I'm never going back. And I didn't. I was just so mad. Christine, these creators, if you guys knew the difference, like I'm not trying to say I'm not trying to like be like, oh, poor me, because I know what I got myself into. But these people are making bank. Like they are making so much. I couldn't even believe it. Like I'm just like, but as a Ponzi scheme. Someone someone said one day that me and Granny sound alike when we talk. And I'm like, it's probably the accent because I'm from Philadelphia, but I moved to Ohio when I was little. And it still comes out here and there. Look at that. Well, Ladybug, have a wonderful time. Your granddaughter graduates from college. That's so awesome. Oh my God, Ministry of Defense. I make 1/15 of that. Or less. That's awesome, Ladybug. So I'm here for the people. I'm here for the cases. I'm here for y'all. I mean, I really am. Because if not, I could just we all could what everyone's doing right now with the BJ content. It's easy to pick on her. It is so easy to go after her. I could fire up a live, put her live on from the night before, and just make fun of her. And my channel would grow a lot. But those people are not who I want over here. You know what I mean? I want safe people. I want it to be safe and fun and no drama. So that's what we just try to stick to ourselves over here. You've worked so hard, Squeaky Wheel. I don't know why that Ladybug just won't get a divorce and just be like, I'm divorcing you because of Squeaky. Ladybug, he has tortured you for some months, though, hasn't he? I think it's funny. I think it's so funny when Squeaky gets to Ladybug. I would be. Can you imagine that drama? Like, I couldn't do it. I couldn't do it. Like every day, all day. I just listen to her on other channels. That's the only time I listen to it. But I'm going to jump off of here. I'll be back on tomorrow at 9:15. We're going to watch a couple videos that are like a little bit longer of the interviews. And yeah. Me too. I was back away from YouTube. I need to take a break, I think. I think once we hit 20,000 subscribers, I'm going to take like 2 or 3 days off. I know that doesn't sound like a lot, but to me, that's a lot. I think I'm going to do that. Oh, we were talking about, I think, BJ. Brittany J. She wants to go by Brittany J now instead of BJ. I don't know. People would be weird. That'd be like me changing my name. Like, I mean, I don't know. We've known you for that, for that name. I don't know. But thank you guys for being here tonight. I appreciate you. Thank you so much. Mary Beth, thank you for gifting out so many memberships. And Christine gifted out 5 memberships, and Be Happy gifted out some memberships. So I appreciate that. And Mancha Chi, love y'all. She said with the $1.99. That was so sweet. Thank you guys so much for being here tonight and hanging out with me. And I will be back tomorrow night. Yeah, I'll be back tomorrow to hang out with you guys. So I'll see you guys all tomorrow. Have a wonderful Friday. Have a wonderful Friday. It's Friday. We're almost through the weekend. One more day. Bye, guys.
Just like the street lights lit this town, like a fire in a blaze, gotta burn it down. Can't be afraid to leave this out. We got this far, don't know